Good evening to our friends in Washington, D.C., and good evening to everybody here in New York City. I'm Ron Collins, and along with my colleagues Seth Berlin and David Scover, we co-chair the First Amendment Salons with Lee Levine, one of our emeritus colleagues. A little plug there for Lee as well. The Salons now are in their sixth year in association with the Floyd Abrams Institute for Freedom of Expression at Yale Law School. And again, Floyd, thank you for your cooperation and the cooperation of the Institute and all the wonderful things they do. We're happy to be able to co-partner with you in these events. The salons were designed to engage members of the First Amendment community, journalists, professors, activists, lawyers, and others, to engage in robust discussion about various topics that are important in contemporary society. To that end, we've been very fortunate to have quite often members of the bar and members of the academy engage in robust and always civil discussion. And tonight we are in that tradition. We are really quite fortunate to have the panel that we do. And they will be discussing the Second Circuit case of Knight, First Amendment Institute versus Trump. And Francesca will be talking about that in a moment and setting up the facts for this evening's discussion. You have before you the biographical statements of each of the panelists. And so I won't have to spend a lot of time, but I'll very briefly say just a couple of words about each of them. First of all, to my far left is Jameel Jaffer. He's the executive director of the Knight First Amendment Institute at Columbia University, and he successfully co-argued the case that we'll be discussing this evening. Jameel, welcome. We're delighted to have you. And next to Jameel is Noah Feldman, who is the Felix Frankfurter Professor of Law and Director of the Julius Rabinowitz Program on Jewish and Israeli Law at Harvard Law School. And I just want to say, I don't usually plug books, but this is a really incredible book, The Three Lives of James Madison. And for those of us interested in First Amendment and First Amendment law, I highly recommend this book to you. And no, Noah didn't ask me to plug the book, but it's a wonderful book. And I'm hoping that I hope I can get a signature from you afterwards. Noah, welcome. And finally, Francesca Procaccini, did I pronounce that correctly? I'm the child of a mother born in Naples, Italy, so she would have scolded me if I got that wrong. Francesca is a clinical lecturer at Yale Law School, and she has, among other things, co-authored briefs presented to the Supreme Court with none other than Floyd Abrams. So, Francesca, welcome. What the program is for tonight, that they'll go on for about just under an hour. And then we'll turn it to you for questions, including questions from Washington, D.C. So D.C., please be prepared to have some questions, not to overlook everybody here in New York. And we're going to start off with a moderated discussion with Francesca and the two panelists. And then later on in the evening, we'll turn to your questions. With that, I turn it over to Francesca. Welcome.
So if I use this, I think everyone can still hear me, and I'll give that to you. Wonderful. So welcome. Thank you, everyone. I'm going to briefly summarize the case, emphasis on brief. It's a really interesting case, but I will allow our two speakers to dive into the most interesting aspects of it. So the Knight Institute and 7 individual plaintiffs filed suit against the president and some aides in July 2017, alleging that the president had blocked these 7 individuals on Twitter, and it was conceded at some point in the litigation that it was because of their criticism that they had written on Twitter. So the president blocked them. They filed suit, claiming that the blocking violated their First Amendment rights. Both the individuals claimed the violation was against their right to petition the government, and the Knight Institute alleged that their First Amendment rights to read the replies of these blocked individuals or to otherwise engage with dissenting voices in this virtual public forum was violated. They won in the district court before Judge Buchwald in the Southern District of New York, and the government appealed. So exactly 2 years later, almost to the day, very speedy litigation, the Second Circuit issued its ruling affirming the district court, holding that it does violate the First Amendment for a public official who uses their account for official purposes to exclude persons from an otherwise open online dialogue out of disagreement with that user's views or postings. I hope you noted all of the different outs that are possible in that holding, but that's the narrow holding of the case. And in getting there, the court rejected essentially 3 of the government's counter-arguments. First, that the blocking was not state action. Second, that the account is not a public forum. And third, that the blocking was government speech. So the first 2 arguments the court got rid of by pointing to the overwhelming evidence that Trump's Twitter is at least currently operating as an official state-run account. The court steeped this conclusion in a pretty fact-intensive overview of the account, pointing to the account's appearance with official photos, to the predominant use of the account for things like announcing policy decisions or appointments, as well as the White House's own characterization of the account as being the official word of the president. So for this reason, both the blocking was deemed to be state action, and then the virtual comment space, let's call it, that these tweets create were designated to be a public forum in which the government cannot engage in viewpoint discrimination. As to the government speech argument, that the court accepted that the president's initial tweets are government speech, but that the blocking function is an interactive feature that more closely resembles an exercise of control over another person's speech than with the government exhibiting its own message and speaking as the government. I think this part of the analysis is not as fleshed out as it could be, but again, appears to rely on the fact that blocking is some sort of a step removed from simply putting out a message, as opposed to, a step removed from putting out a message and more akin to a state form of interaction with someone else's speech. So those are the 3 arguments on the table. I think, or I hope, there is some maybe debate that could be had over them. And yeah, I have questions to help us along, but I think I'll turn it to you guys for initial comments, and please feel free to take it away. If I don't have to say another word, you've done your job.
So, all right, well, first, thanks for the invitation. Is this on or no? Should it be on? Okay. Thanks for the invitation. This is an intimidating room to speak in. I knew that Noah and Francesca would be next to me. I did not know that Vince and Floyd would be right in front of me. Thankfully, I have my co-counsel, Alex Abdo, here, who's going to take the hard questions. Let me just start by saying something about why we brought this case. Because when it came to us, when we first started thinking about this issue, it wasn't immediately obvious to us that it was a case that we should file. We did consider these arguments about whether the president was acting in his personal capacity or his official capacity. We also thought through, is the burden here really substantial enough to warrant our involvement? Is this something, maybe this is just a frivolous issue, this issue of people getting blocked from social media accounts. We spent a lot of time thinking about these things, and I want to tell you why we ultimately decided to file the case. And we came to the conclusion that the most important speech in our democracy right now is taking place in these social media accounts. Now, that may be a terrible comment on our democracy. We can debate that. But it is nonetheless, in my view, a fact that the speech that matters most to democracy takes place in these accounts. This is where people get information about public officials. It's where they interact with other citizens, especially about the speech of public officials. Often it's where they learn about government policy. And because that's the function that these accounts are playing, these accounts, I mean social media accounts of public officials, because that's where people get their information, where they interact with one another, where they make their decisions about who to vote for, what policies to support. It's important that these spaces be free in the sense that the First Amendment has always, intended public forums to be free. So President Trump is, notable in, for the extent to which he relies on social media. But he is not the only public official who does this, right? Public officials all over the country now use social media as often their principal means of communicating with their constituents, giving information to their constituents, hearing from their constituents, allowing their constituents to communicate with one another, often about government policy or government decisions. This is happening all over the country. It's not just that people that participating in self-government now often involves participating in these social media forums. It's also that at a much more mundane level, this is where people get information about the government. After or in the days leading up to hurricanes that landed in the US in 2017, public officials in Florida, in Texas, in Puerto Rico, all use social media to give their citizens information about where to find shelters, where to get emergency relief. They gave advice to citizens who stayed in their homes rather than evacuating. They gave safety advice to citizens who stayed in their homes. So even at that level, these accounts are playing a very important role. And we were approached by a number of people who had been blocked from President Trump's account after they had criticized him for his policies or criticized his views in one way or another. All of this was, entirely, not that it needed to be, but it was all very civil. And one of our eventual plaintiffs is a doctor who criticized President Trump for typos in his tweets, saying, "Should somebody who writes like this have control over the nuclear button?" Another one of our plaintiffs is a legal journalist who made a comment about Trump and Russia and was blocked for that reason. Another is a former police officer who made a comment about President Trump's healthcare policies, blocked for that reason. And it bothered us more and more that people were being blocked from this important forum on the basis of viewpoint. And the more we thought about it, the more we thought that the same rules that have always applied to public forums offline should be applied to these places too. And that if you don't apply those rules to this set of digital forums, you will end up with forums that are cleansed of dissenters. You will end up with the spectacle of unanimity, where with people, if you scroll down President Trump's comment threads, all you'll see are supporters, because the most trenchant critics have been purged from that space. President Trump will be insulated from criticism. The rest of us who haven't yet been blocked will be denied the ability or denied the opportunity to hear the speech of people who would have dissented. And that, the more we thought about it, the more we thought this is what the First Amendment is for. We need the protections that have applied offline to be applied online again. Let me leave it there, because I can tell that Noah already has objections.
First of all, it's an honor and a privilege to be here with Francesca and with Jameel. Jameel and I are contemporaries. Francesca, I'm proud to say, was my student. And I'm also very grateful to Ballard Spahr and to Floyd for being Floyd. And I should say Vince was incredibly generous and kind to me when I was a little bitty baby professor, and I remain extremely grateful to him for that. I want to begin by saying just that I have huge respect for the work that Alex and Jameel did on this case, and I also have great respect for what the Knight Center is doing. we're all on the side of free expression here, I think strongly. What we have is a meaningful disagreement about what will actually maximize free expression, not just in this case, but much more importantly in the next several decades. And so I want to just, in responding to Jameel's very good opening statement, make it really clear why I think free expression is on the other side of this one. And I just want to, before I do that, I want to add one disclosure, just to be fair, in the spirit of disclosure, which is that for the last couple of years, I've been working with Facebook on their oversight board, colloquially called the Facebook Supreme Court, which is in fact designed to provide greater free expression protection on the platform than they presently have. Whether it will do that or not remains to be seen, but that's the intent, and it's supposed to launch in Q1. So I'm absolutely not speaking on their behalf. I don't think I share their views on everything, but I just thought it was fair to mention that in context. Okay, so why is it that I think that free expression actually lies on the other side? Here's why, and Jameel's comments perfectly exemplify this. There's no question that social media is a kind of revolution of expression roughly on par with the printing press. And in the aftermath of the printing press, we got a new human institution, the newspaper, the printed newspaper, which has had an extraordinary and transformative effect on human history. You know, the theorists of nationalism, think of Benedict Anderson's famous book, The Imagined Community. They believe that and they argue that there could never have been the modern nation state without newspapers. Okay, so the newspaper has been an absolutely central transformative institution, and I take it that archetypally, our support of free expression is not just support of people talking, but it's support of the institution of the newspaper. That's why the First Amendment speaks of the freedom of the press as an institutional frame, and it's also not at all an accident that the only part of the Constitution that specifically refers to a technology, a particular technology, is the phrase freedom of the press. We use it all the time metaphorically to mean all kinds of expression, but the word press has a literal meaning. It's a printing press. Okay. Now, many of you, Floyd most famously of all of us, have defended the First Amendment and free expression by defending actual institutional newspapers. To me, the leading question for this current era of speech is what institutions are most closely analogous to newspapers for this new period of time? And to me, the answer is the platforms, the social media platforms, that facilitate all of the other expression, that are the ones being subject to withering critique, the same way newspapers were. Newspapers were accused of, and the printing press was accused of destroying existing political institutions. They are subject as well to intense governmental regulatory pressure. Again, just like newspapers, which were subject to direct censorship for most of their history. Now, when I listen to Jameel talk about concerns of introducing free expression rights on social media, and I hear him say, and I think I'm quoting you here because I wrote it down, we want free expression, quote, to apply to these places too. The place in question is the place of social media. So I want to first make a conceptual point about why I think this is deeply misguided in a big picture historical way for the protection of free expression. And second, a much narrower technical point, which I think will dive us into the particularities of the case, and which is about the second of the issues that the Second Circuit decided. So at the big picture level, to me, the question is, where does this decision, this litigation and this decision, lie on the process of governmental regulation of social media platforms? And to my mind, what happened here is that the government regulated a social media platform. And the Second Circuit decision, the Second Circuit is also part of the government, right? It's a mistake to think that courts are always necessarily on the side are not part of the government. They are governmental institutions. The Second Circuit's regulatory decision here, compelling a form of speech, as I will argue, on Twitter, compelling that speech on Twitter, which Twitter, by its preferences as a company, did not wish to allow. So I believe this is a decision in which the Second Circuit compelled speech on Twitter. That decision moved us slowly in the direction, doesn't get us all the way there, it's not part of the holding. The court bends over backwards to say it's not saying this. And by the way, as you all know, when a court bends over backwards to say it's not saying something, it's because they know that, like in the next case, it can be read as saying that thing. This is a step in the long-term direction of imposing First Amendment restrictions on social media. And if that happens, if the courts decide that the First Amendment applies on social media platforms, that will be the greatest removal of free expression protection from institutions, namely the platforms, in US history. And when it happens, if it happens, it will happen under the guise of the expansion of free expression, on the theory, just as Jameel said, that so much important expression is happening on social media that we just have to apply the First Amendment to it. And if that happens, we can talk about this at greater length, but if that happens, it will remove free expression effectively via compelled speech model from these platforms, most of which will collapse in the aftermath of that. And they will collapse, and now I come to my technical point, they will collapse because the product that these social media platforms are selling, in the same way that a newspaper is selling a newspaper, in which editorial decisions are constantly being made by the newspaper about what they will publish and what they will not publish, the social media platforms are selling a product which includes the capacity for individuals to be their own editors, to curate the content that they see and the content that they produce on the streams that they offer. Take those capacities away, people will not use those platforms. And there's some real world examples of platforms. Tumblr is a great example, which allowed pornography, unlike, say, Facebook or Twitter, and it took over the site, and the site lost all of its value. They attempted to relaunch. They're not doing very well. They will probably be in bankruptcy soon, right? And this is a product of their making a wrong initial determination about the question of editing content and controlling content on their site. So my first point is to urge you to make a conceptual realization that the product of the platforms is just like the product of a newspaper. And if you made the New York Times publish every op-ed that everyone has sent in, the New York Times would be Medium. It would no longer be the New York Times. So that's my first conceptual point. Second conceptual point, requiring Twitter to arrange things so that Donald Trump cannot limit people from responding to him whom he chooses to quiet is itself an act of compelled speech. And if you don't like Donald Trump, no problem. Let's talk about Alexandria Ocasio-Cortez, who is in exactly the same situation now, who felt that on her Twitter account, she should be able to block, like every other person can on Twitter, racist, misogynistic, harassing critics. And is now, I hope and trust, that you guys will now sue her on the same exact grounds if you wish to be consistent. So I'd like to use her just because Donald Trump, I've spent the last while dealing with impeachment matters. I'm going to be back. I was on television this morning. I'll be back on it this afternoon. Trump derangement syndrome is a thing, and I think we should be very clear and not allow that to affect us here. Okay, last, the technical point. I think there's a conceptual technical error in the Second Circuit's decision, and it's in the middle bit. Francesca spoke of, and she had to make this term up because the court didn't really use this term. I think you said the virtual comment space. Mm-hmm. That's the space which the whole case is about. The only thing at issue, it's not that Donald Trump can't speak, he can speak. It's not that the people that he's blocking can't speak, they can say anything they want on Twitter. The only question is, can they say that thing in the same exchange space, what Francesca called the virtual comment space, back at Donald Trump? So when you talk about like announcements of the weather, or disaster relief, they can access that. They just can't virtually comment in response. That's the only speech that's in question in the case. Now again, the core of my argument at the sort of doctrinal level is that the court mistakenly treated that as a public forum, as a limited public forum. Why? Because the court made a conceptual mistake in assuming that the default position of that comment space is that it's open. But that's not the default position of that comment space. On my Twitter account, on AOC's Twitter account, I can allow nobody to respond. I could block everybody. I can only allow my friends. On my 13-year-old daughter's page, I can assure that only her friends are allowed to respond to her to protect her, or for her to protect herself. So that space is not open to all. And if it were, there would be no Twitter. The capacity to block people from responding to you is built into the essential structure of Twitter. Therefore, it was never a public forum in any sense of the term. Not designated, and if so, who would have designated it? Not Donald Trump. He didn't designate it. Twitter would have had to designate it. So the court made a mistake, and I'm an old guy too, or at least a middle-aged guy, so I can say it's an old or middle-aged person's mistake to think that it's just naturally the case that anyone can respond in that space. It's not, and anyone who's a digital native would tell you that. So just at the technical level, and here we really can disagree, there was no limited public forum in this case. It never existed. The court got it wrong. And over time, I hope there'll be generational change. There'll be more digital natives deciding these cases. And they'll know that and get that. So I think on the doctrine, that might be the only point where we really actively disagree, although maybe there are some others too.
All right.
I think you have enough to just respond
Yeah,
without
just go.
getting into interluding.
So, okay, a few things. First, Noah quoted me correctly. I said, we want this body of law to apply to these places too. I should have been more specific about which places I was talking about. I'm not talking about Twitter or Facebook. My argument isn't that the First Amendment applies to Twitter or Facebook in the sense that Twitter can't exclude people from its platforms based on their viewpoint. The argument we're making in this case is not about the platforms generally, but rather about the social media accounts of public officials who use those accounts as extensions of their offices. All right, so that's not Twitter. Most people on Twitter are not public officials, and many public officials have social media accounts that they don't use as extensions of their offices. But President Trump uses his account as an extension of his office. And I say that for a few reasons. First, he uses government resources in the service of this account. He relies on his White House staff to draft tweets, sometimes to post tweets. They have access to the account. Dan Scavino, his social media director, I think his main job is to help operate this social media account. We also know that President Trump uses the account as an extension of his office in the sense that he uses the account to announce official policies, to announce official decisions. He has nominated or announced his nomination of Chris Wray as FBI director, John Kelly as chief of staff. He fired Rex Tillerson as Secretary of State using his Twitter account. He lifted sanctions on North Korea using his Twitter account.
I concede all of this, but I think it's beside the point. Go on.
Well, your argument, I want to make clear that the slope that you are claiming is very slippery is not nearly as slippery as you think it is, right? Because your argument is that by holding that these social media accounts are subject to the First Amendment, the court has effectively held that Twitter and Facebook can't make these decisions. No, not that it's effectively held,
just that it's the first step in that direction. And
I
wonder if that would make you unhappy. I know for this case you argued it narrowly, but isn't that what you actually want?
No, not at all. I would be very unhappy if the Supreme Court said that Twitter can't do anything that the government can't do on Twitter's platform. I'd be very unhappy. I don't think that would be a good result at all. But that's not the question presented by this case. And I think that there's a very clear line between a holding that says public officials can't engage in viewpoint discrimination and a holding that says Twitter can't engage in viewpoint discrimination. And my view that that difference is significant is not just my view. It's also, I think, Twitter's view, because Twitter filed a brief in this case, well, the Internet Association filed a brief in this case in support of neither party, saying that we don't have a view on this particular issue of whether public officials should be permitted under the First Amendment to engage in viewpoint discrimination, but we don't want the court to hold that Twitter can't engage in viewpoint discrimination. So I think there's a very clear line between those two things, and I don't think the slope is as slippery as you think it is, or even slippery at all. And if I did, then I would feel very differently about the case that we've brought. Trump derangement syndrome. Trump derangement syndrome may be a thing, but Trump derangement syndrome is also a thing. We sent a letter to AOC, after we learned that she was blocking people from her account on the basis of a viewpoint. And we pointed out to her that the Second Circuit had recently held that viewpoint-based discrimination in this context was unconstitutional. We told her it was our view that that her account constituted a public forum under the First Amendment. And after we sent our letter, she changed her policies. She apologized to one of the people whom she had blocked on the basis of a viewpoint. And if she decided tomorrow to start blocking people on the basis of viewpoint again, we would be contemplating litigation in the same way as we are with respect to other officials who are engaged in viewpoint discrimination. So I know you're right that there are some people who cheer our victory in the Trump case on the basis of partisanship. We try not to be partisan in our work.
Can I see a quick response to that before you go on? Just
Yes,
very quickly.
absolutely.
I mean, that's great that you're consistent. I think that's a good example. It just shows that you chilled her speech, to me. I mean, she will now be much more careful and much more reticent about speaking in that forum, because if she engages in that forum and she is attacked vastly, as she indeed is, just look on her, you can do it right now, look on her feed, by misogyny and all other sorts of vile hatred, racism, you name it, she gets it. She now can't protect herself against that in a way that the platform is designed to enable her to do, and that will push her ultimately, and others like her, off of these platforms. And you'll say, well, she was a government official. I mean, notice, she has no legal authority as a government official to even designate a public space. She's just one member of Congress. I mean, even from ordinary, talk about slippery slope, even from ordinary designation perspectives, the president maybe can designate space under some conditions. How can she designate space? She doesn't. She's just one member of Congress. So
Can we go there for a second?
I know you have a lot more to say, but I do think this is an important issue.
But I also think that that's important. Where does the decision leave us in terms of what can public officials still do now that the First Amendment applies to protect, either protect themselves or even just shape the discourse that they want to have with their constituents? Time, place, and manner, is that a tool? How does that work? Who is creating this manner? Right. It's one individual, not right. So maybe.
Yeah. So first, I'm not unsympathetic to this argument that especially on social media, harassing and abusive speech can chill other speech that is valuable to our democracy, and that we don't want to chill. On the other hand, if you are a public official, something that comes with the job is being exposed to the criticism, often unfair, often uncivil, of citizens. And there are many things that you can do to sort of mitigate the problems of abuse and harassment. I'll come to that in 1 second. But I don't see that allowing public officials to engage in viewpoint discrimination is a solution to this set of problems. And the only thing we've established in this case, and I'm glad we established it, is that public officials in this particular context can't engage in viewpoint discrimination. They can't exclude people from these spaces simply because they disagree with what they have to say. Now, where does that leave them? I think it's a very good question. We released this document just a few days ago, which is meant to be guidance to public officials who are thinking through how to use their social media accounts in ways that don't run up against the First Amendment. And we walk through a few options that are available. I don't think this is at all exhaustive, but to start with the easiest, you don't have to tolerate true threats. You don't have to tolerate obscenity. You can also impose viewpoint neutral rules. So for example, some public officials have complained about specific speakers hijacking their comment threads, like posting over and over, often the same content. If you wanted to, you could impose a rule that said, you can't tweet at me more than X times a day. I think that would be a viewpoint neutral rule. I'm not saying it would be a great idea, especially for somebody who had millions of followers, but you could impose that kind of rule. I think it's conceivable that you could impose a constituent-only rule if you found some way to actually reliably distinguish your constituents from other people. And the forum, you sort of articulated the purpose of the forum in some way that made the limitation to constituents reasonable. But there are strategies like that might go some way towards mitigating the problems of abuse and harassment. I'm not going to pretend that those are a complete solution. They're definitely not. But if you think about the First Amendment cases that we usually refer to as sort of the pillars of First Amendment doctrine, public officials have been exposed to the worst speech forever. This is not a new thing. And I don't think that we address that problem. We've never accepted viewpoint discrimination as a way of addressing that problem. I don't think it would be effective at addressing that problem. And the results would be, the disease. I'm not sure what the right analogy here is, but the fix would be worse than the problem itself. So I guess that's what I'd say on that front. Now that said, I want to concede one thing, which is I think that as you get away from executive officials, it becomes a complicated question. How to draw the line between social media accounts that are being used as extensions of an official office and social media accounts that should be characterized as as personal. With Trump, it's relatively easy because Trump can. He can engage in kind of speech acts through his account. He can make things happen in the world through his account. And a member of Congress who doesn't have, it's different if you're the chair of some committee or something, but if you're just the ordinary member of Congress or an ordinary legislator, you may not have that ability. Even then, I would say, there are factors that would make me conclude that a legislator's account was being used in a way that the First Amendment should care about. For example, the legislator uses state government resources in the service of the account, or the legislator uses an account that he or she has only because he or she is a public official. So, for example, AOC had a @AOC account before she became a public official. Once she became a public official, she adopted another account @AOC, @Rep AOC. And that account is subject to rules imposed by the House, and it's an account that she has only because she's a public official. And I would say that's another factor to be considered in deciding whether a public official's account should be considered a public forum. But I acknowledge that once you get away from executive decision makers, it's the burden should be heavier on plaintiffs who are arguing that those are official accounts.
There are tons of interesting things here. I just want to go back to the big picture point, Jameel, when you were saying that you're not interested in regulating and imposing First Amendment standards on Twitter itself. And here I want to suggest that not only is the slope slippery, you're already pretty far down it. So, imagine this. So all of the platforms have terms of service rules. Now imagine you're Donald Trump or you're AOC, and you say, okay, well, because of Jameel's case, I can't block people from Twitter who are harassing me, because that's their viewpoint, right? St. Paul against, RAV against St. Paul says so. Hate is a viewpoint. The court has reiterated that in recent years. But I could at least report to Twitter that there's been a violation of Twitter's terms of service. And then Twitter will take this person down if they've, said something that's misogynistic or racist, because Twitter's terms of service, under some circumstances, prohibit that form of speech, because Twitter is not limited by the First Amendment. So now I report it. Well, now am I a government official engaged in the act of blocking someone and engaging in, as you put it, viewpoint discrimination? I'm not going to take them down. Twitter's going to take them down. Now, I think you're stuck on the following dilemma. And this, by the way, this is real. This is not some abstraction. This exists now. So but if you take the view, well, let me explain why. Okay. So if you take, I don't know which view you'll take, but if you take the view that that's not a problem, of course she can report that to Twitter, and of course they can take it down. There's no difference between that and her taking the content down in the following sense. Twitter has a feature built in that says, under its terms of service, they will block certain content. Twitter also has a feature built in that says the user can block that content. Those are not analytically distinct. Those are both things that Twitter built in for the convenience of the user. And if you go the other way and you say, no, she can't go to Twitter because if she goes to Twitter to tell them about it, then after all, she's colluding in, and she might advocate to Twitter. People do this all the time. They advocate to Twitter. Then she's effectively content discriminating.
Yeah, that's
then
my view.
that is your view.
Yes.
That she can't report. So now notice the following. Now she can't avail herself of the most basic, capacity that every Twitter user has, namely just to raise their hand and say, hey, there's been a violation of the terms of service. Again, notice how her speech is being restricted and how her speech is being chilled. Let's say she just wants to issue a press release. She doesn't call Twitter. She uses her press release and she says, hey, on my site, lots of people are violating the terms of service by harassing me. Jameel's going to then have to say, she can't hold that press conference. She can't alert people to the fact that Twitter's terms of service are being violated, because after all, that's just an effective way of drawing Twitter's attention to this violation of the terms of service. And my point is, this isn't theoretical, this is now. I mean, what all these social platforms do every day is wait for reports that could be from the user or from somebody else, violations of terms of service, and then they sanction. So you say there's no slippery slope. We're living in the slope. The slope is sliding. We're on the sled sliding down it right now.
The end of that slippery slope is that you can't even have, is that you're advocating policy about platforms that's very...
Right, even if she stands up and says, I think they should change their policy.
I thought the slippery slope that you were worried about was Twitter is now going to be subject to the First Amendment. I don't see how anything you just said leads to Twitter being subject to the First Amendment. I think my view is that if a public official who uses her account as an extension of her office, rather than suppressing the speech of dissenters on that account, goes to Twitter and says, hey, can you guys suppress the speech? My view is that that violates the First Amendment. You'd have to ask, does it rise to the level of coercion? I think that a mere request might not be a violation, but something more than a mere request might rise to a First Amendment violation. But whatever the answer to that question, it doesn't result in Twitter being subject to the First Amendment. Twitter can do whatever it wants to do. It can change its policies tomorrow.
No, it can't for the following reason. What Twitter has is a social media platform, call it a newspaper if you wish, and one of the features of that newspaper is that it confers on users certain capacities to edit, just like someone in a newspaper would do. It's think of it, it's an edit-it-yourself newspaper. That's one way of understanding what social media platforms are. And Twitter's product, which enables you to block people you don't like, and which also enables Twitter to take people down when it doesn't want to take them, Twitter's platform cannot be used the way it was designed by government officials. That affects Twitter right now. If it led to government officials using Twitter less, if Donald Trump got off of Twitter because if he were sensitive and got off of Twitter because that's why it's better to use AOC as an example, if you imagine some new politician who gets off of Twitter because he or she is upset to no longer be able to exercise these functions that everyone else can use, that will have an effect on Twitter. That will make Twitter less capable.
Okay, so if your argument is that our case will have an effect on Twitter, then maybe I'm on board. I thought your argument was that our case will result in the First Amendment binding Twitter.
I think
your case
already involves the First Amendment indirectly binding Twitter because it says that the phenomenon that is Twitter, the newspaper that is Twitter, cannot confer its editorial function on certain people, government officials. They're now excluded from Twitter's project. Twitter began by saying, hey world, including politicians, come on our site and produce content through this self-editing method. And now they can't.
There's a difference here between, I think, the slight talking past is whether or not Twitter's First Amendment rights are being violated by the result of the decision is that Twitter's First Amendment rights are being impinged upon, and whether or not the First Amendment applies to Twitter such that Twitter now has to, it's not that their First Amendment rights are being violated, but that they are subject to the First Amendment.
So let me make the strongest form of the argument. This may go too far, and I haven't made this in writing, but let me just try it. So think of it as a free association right? Right? Twitter has a free association right. We're all going to agree with that. One of Twitter's free association rights is that it says the following: we don't want to associate. It's expressive association. We don't want to associate ourselves with the speech in the virtual comment section of anyone whom our user doesn't want to have. Right? That's Twitter's position. Right? If Francesca blocks me in her comments, Twitter says, we don't want to associate with Noah in her virtual comment section when Francesca chooses to block. That's our associational choice. And I think that associational choice is free speech protected, it's First Amendment protected. That associational choice is taken away just by the holding in Jameel and Alex's case. Twitter can no longer dissociate itself from me in Francesca's comment space. I think that's significant. And I think, I'm trying this on for size, I think that actually is compelled speech, compelled dissociation of Twitter itself, even if Twitter doesn't know it, if they haven't thought it through enough to get it.
Okay, so I have a few things to say, the most important of which is, I should have mentioned at the beginning, I mentioned Alex because he's here, but our other co-counsel in this case is Katie Fallow, and she argued the case, co-argued the case in the district court. She also argued Davison v. Randall, which is a case raising similar issues in the Fourth Circuit. And she's not here, which is why I didn't mention her earlier, but I should have. I want to try to tackle this from a different angle.
And then we'll invite questions.
Okay, so no, if your basic argument, and maybe you'll correct my my paraphrase of it, but if your basic argument is it can't be a public forum because it's taking place in a space that a private, it's on private property, and not just on private property, but Twitter has ultimate control over who can speak here and what can be said in this forum. You can't have a public forum on property like that, or we shouldn't recognize public forums.
I'm with you. Just the only tweak is, unlike like a shopping mall or an otherwise relatively neutral space, it's crucial to my argument that Twitter as a platform is all about expression, that nothing that happens on there isn't expressive. Unlike, say, you go shopping and that's not an expressive act.
Right. So is your objection, do you have the same objections then? What's your view about at POTUS and at White House, which are, the government itself characterizes, these are as official as they can be, right? They're handed down from one president to the next, from one White House to the next. If tomorrow at POTUS starts blocking people on the basis of viewpoint, or even leave at POTUS aside, and at DHS, so DHS has a website, they have a blog on their website, they provide information about, it's an interactive blog, provide information about immigration law, border policy. They start blocking people on the basis of viewpoint. Same thing?
I have the same view, the same as if they had took ads in the New York Times.
So this
just
is
like if they took it out in the New York Times.
This is the slippery slope, right? This is the slippery slope, because your adopting your argument means that you effectively can't have a public forum online, because everything that takes place online takes place on private property. It's not just the social media companies. The government relies on web hosting services.
No, there's a difference between non-expressive things and in the same way that there's a public space that isn't the New York Times, and then there's the New York Times.
Okay.
And this is about social media platforms their business program is. This is how they think about themselves. This is what their business is. They are editorial entities. They are newspapers. And I know you guys, I see some skeptical faces in the audience, and I'm telling you, don't be Luddites about this. Like, this is the new technology, and the platforms have value as opposed to the old internet. Remember before social media, where you just went online and posted whatever you wanted? That was different, and that's fine. And they can create a website and say whatever they want. And if a government website is on the website, absolutely they have to. Absolutely, that's public.
But what is the expressive content of this decision to allow? Twitter's decision to allow its users to block other users. How is that any different from the decision of a shopping mall to put this store here rather than there?
Jameel, because it's the whole business model. What makes Twitter different from Facebook and Facebook different from Tumblr is that they have different rules. They all have different rules and mechanisms for how you can construct the speech space around you. Like, that's what their whole business is, their curation function. It's like why the New York Times is different from a public access channel. They choose which articles are going to go up there. This is just the New York Times with a twist. And by the way, if you don't believe that, the New York Times itself is in the process of becoming this. So the New York Times has comment sections, okay? Those comment sections you could easily describe. So now Donald Trump writes an article for the New York Times. There's a comment section. Some newspapers give the authors of their articles the authority, they confer on that person the authority to block certain comments that comes in. Now you're going to tell me that the New York Times itself cannot allow Donald Trump to block certain comments in its own comment space. Maybe that makes it better for you if it actually is the New York Times.
I'll stop after this, but I just want to clarify this. Our argument is not that the New York Times or Twitter, let's accept your analogy for now, that they can't prevent Donald Trump from blocking. Our argument is that Donald Trump can't block himself. That's it. The injunction runs against the president. It doesn't run against Twitter. It doesn't run against the New York Times. It runs against the president.
Open it up.
Jameel,
Yes, Floyd.
suppose, let's leave Trump out for all sorts of reasons. Suppose AOC wants to communicate with her followers, her supporters, and she creates a site and she announces that it is for my supporters. I'm not keeping anyone else off, but this is for my supporters, and she then does keep someone off who is, expressing consistently adverse views to her position.
Right.
What result?
I think much harder question. That is not the situation with most public officials now, right? Noah said earlier that the default.
Agree.
Right. So the default.
But I'm deliberately
right.
asking it in terms of a public official
Yeah.
who is not holding himself, herself out. I'm the mayor. Come talk to me.
Right.
But it's saying, mega.
Right.
I mean, the next question would have been Trump.
My instinct.
I want to have
right.
a website. This is a website for my followers.
Right.
And Jameel, what's your view about a real world rally? Do you think the president can, as he did when he ran for office, can you
Right.
the
So
Coliseum?
what I was going to say in response to Floyd was that, to me, it seems more like a real world rally where it's more of a campaign event than you're acting in your capacity as a citizen seeking re-election rather than in your official capacity as a government official. But it does remind me of something I wanted to say in response to. Noah's right that many social media platforms do allow you, and this is certainly true of Twitter, to have protected accounts or to limit your followers in these ways. Trump has not done that. Trump, from the beginning, has opened his account to everybody. Has not made any attempt to curate it, except at the very far margins where he has curated it in the sense that we've challenged in this case. This is a situation where the government, the president, has invited anyone and everyone to participate, and then excluded a handful of people, or 100 people, based solely on their criticism of him. It's the easiest case. I am not denying that there are harder cases.
I want to make sure I get DC in, and then I'll come back. I don't. Yes, the one waving.
Yeah, that would be
Ashley,
me.
you might do this.
Thank you. I'm Ashley Messenger. I'm the First Amendment lawyer at NPR here in Washington, D.C. And I want to raise an issue about the analogy that Professor Feldman used comparing social media platforms to the New York Times. I think that's very troublesome for several reasons. The first is that the social media companies themselves have held themselves out as not being like the New York Times. Section 230 is premised on the idea that they are treated differently, that they are service providers, not content providers. And unlike traditional media companies like us who are on the hook for everything that's published, they specifically get immunity because they do not control the content in any way, shape, or form. And so you can't have it both ways. You can't say that you're just the service provider and you don't actually control content, but then also want protection for content. That would be very troublesome. I think the better analogy is that Twitter is more like pen and paper. It is a means of communicating. You can do lots of things with paper, right? You can burn it, you can throw it out. The business model of paper is to make it easy to use and to dispose of. And yet we have regulations on how public officials can use paper. For example, they're required to respond to FOIA requests. They have to turn over documents. And there have been government officials who have argued that it violates their First Amendment rights to be forced to turn over their documents. And the courts have said that is utter nonsense. And the reason it's utter nonsense is because philosophically, the First Amendment is designed to regulate the relationship between government and citizen. There are obligations that government officials have that other people don't have. So they sometimes have to do things with technologies that they use, like pen and paper or Twitter or other things, to be responsive to their obligations as officials. And there are other ways that paper can be regulated. If a piece of paper is evidence in litigation, you can't just burn it and throw it out, even though normally you could do that. Because there are times when the control of the information is crucial to fulfilling some other thing, some other interest. And so comparing social media entities to the New York Times as if we're all just publishers doing the same thing, I think is really problematic and harms real publishers, like real media companies that have obligations with respect to content.
So that's great. Can I have?
Of course, have at it.
Thank you.
I really disagree, and let me disagree first doctrinally and then conceptually. Doctrinally, the question of First Amendment protections is a constitutional question, not a statutory question. And even if the media, even people who walk around saying, I have no views, I have no First Amendment rights, have First Amendment rights nevertheless. So Section 230, on your view, doctrinally, would somehow take away the free expression rights of the platforms, and that can't be right as a doctrinal matter. So you say I can't have it both ways? Yes, I can, because the Constitution wins in a battle with Section 230. Furthermore, under Citizens United, like it or hate it, you know, the Ford Motor Company has free expression rights, identical to those of the New York Times. And so the social media platforms certainly qualify, regardless of 230. You know, I have no particular brief with 230. I'm happy to see it go, and probably in a rational world it will go, but it's not relevant as a doctrinal matter or as a legal matter to the constitutional question. With respect to your analogy, though, and this is where we get more fundamental, I couldn't disagree with you more with respect to pen and paper. You know, pen and paper doesn't have a, doesn't have a nearly $1 trillion valuation in the market in the way that many large social media platforms, several large social media platforms do. There's a reason that these things have value in the market. It's because they are producing a unique set of practices and interactions, human interactions, that never existed before, just like the newspapers created a wide range of new forms of human interactions that never existed before. On your view, we could have said, if you were making the same argument about newspapers, you could have said, newspapers are just pieces of paper. I mean, after all, at least newspapers are literally just pieces of paper. But the press is the institutional structure that creates and curates the ideas that are then expressed on those pieces of paper. And social media is exactly the same. It's just come up with a cleverer, newer, deeply threatening to legacy media realization that if you offer people, in addition to curated content, self-editing modes, self-curating modes, it turns out they really, really like that. That was a tremendous expansion in the nature of free expression. Because before then, I could consume the New York Times, and I could make a choice among different newspapers with respect to their editorial, curatorial choices, but I couldn't do that and then simultaneously also shape my own interactive, expressive moments. That's why social media exists. That's what it does. And so they don't have to be exactly like newspapers. They're not. They're replacing, to some degree, legacy media because they offer this extra twist. But that twist is crucially connected to human expression. That's why people like it. And so the new frontier for free expression, this is why this is such an important topic, the new frontier for free expression is precisely those social media. And there is a powerful push, even if it's not Jameel, and even if it's not the Knight Center, there is a powerful push out there from many people who think that the answer is to the answer to this new set of phenomena is for government regulation through the First Amendment to apply to the social media companies and to treat them. And I'm not just attributing that view to Jameel, he said it's not his view, but a lot of people do think this. And those people, I think, are making an epic generational mistake by failing to realize that that would have been like imposing the First Amendment on the New York Times, rather than recognizing the New York Times as itself a free speech actor.
Can I just draw a distinction that may already be obvious to everybody, but I just want to make sure that people get this. There's a difference between saying the First Amendment should apply to Twitter in the sense that Twitter should be bound by the First Amendment in the same way that government officials are, and saying the government should regulate Twitter, right? Your argument that would give Twitter the same First Amendment rights as the New York Times would probably disable regulation, right? Would probably make it impossible for the government to, for example, require Twitter to disclose information about its how it decides what information to put at the top of people's feeds, or information about how it decides what content to take down or what content it's taken down, right? Now, I don't know if those forms of regulation
represent them if that case comes.
Well, so I mean, I'm not sure if that regulation is a good idea or not, but if we're talking about epic generational mistakes, I wonder, wouldn't it be an epic generational mistake to disable the people right now from regulating these entities that have so much control over the speech that is crucial to our democracy? You want to,
but that's exactly what people would have said about newspapers in 1600. What a mistake! If you don't regulate these newspapers, they're going to create a revolution. We're going to have like the Reformation. Catholicism is going to collapse. The nation, yeah, that would have been a reasonable argument. But the truth is that if you believe in free expression, you accept that expressive institutions shouldn't be subject to that regulation, notwithstanding the social costs. That's what it is to believe in free
no
expression.
newspaper has ever had the power that Facebook has over public discourse. Facebook has, on orders of magnitude, more power over public discourse today than the New York Times or any other newspaper has ever had, right? Facebook can decide an election tomorrow if it wants to.
I'm not sure that's true if you go back into the history of newspapers to the earliest period where there were just a tiny number of newspapers that monopolized national discourse in countries that were barely even yet democratic. I think there were newspapers that were tremendously influential and effective.
Not to mention that your degree of power in the marketplace of ideas is not something that the First Amendment typically recognizes as a reason to regulate or not. But
Yes.
see Citizens United.
Victor Governor Davis, right from Maine. I'd like to follow up on Ashley's question a bit, and I think we need a little history here. In the relative infancy of the internet, the platforms went to the Congress and secured the remarkable protection of Section 230. And what 230 did in substance is to say that the platforms are not the publisher of the content which they distribute. And their relatively aggressive history has been resonates very recently when they actually went and got 230, you may all not know this, into the Canada-Mexico-U.S. new NAFTA treaty to protect it from a mere change in legislation, since it's now part of an international treaty, which under some circumstances may preempt legislation. So it's hard to take Professor Feldman's analysis of the platforms as simply the modern 21st century newspaper, because unlike newspapers, unlike book publishers, unlike magazine publishers, unlike radio and television, motion pictures, cable, the platforms alone are protected from any liability for their content. And that distinguishes... Just one final point, Professor, is what was striking. There are two striking points you made. One was the platforms are under regulatory pressure. I agree with that. But what they're not under is regulation. Right? Not under regulation. And the question is it coming? Probably. What are the consequences of it? If you were to drop 230, which I also found striking that you would concede then the analogy to newspapers in the First Amendment context, it seems to be, would be a lot more persuasive.
Let me make, again, briefly the doctrinal point and then a Marxian point. The doctrinal point is really simple. As I said, I'm happy for 230 not to exist. I think in the long run it won't exist. But as a constitutional matter, every lawyer in the room, I think almost all the people in the room are lawyers, every lawyer in the room knows that the existence of 230 can't detract from the constitutional rights of anybody. And basically 230 is an extra benefit, an exemption from certain forms of liability. And you know, they lobbied for it and they got it. Maybe they shouldn't have gotten it. I probably think, my own personal view is they probably shouldn't have gotten it. It should probably be taken away. But that cannot, every lawyer in the room knows, that can affect the underlying constitutional question, which leads me to my Marxian point. So, you know, a lot of First Amendment lawyers, almost all, have historically made their livings by association with legacy media because that's what the job was. And so from a Marxian perspective, it's understandable that First Amendment lawyers who work with legacy media want to say, in the face of the legal doctrine that they know better than I, that it can't be that we should think of the social media platforms as media. It's so unfair. They have this unfair advantage. Now, it's true it's an unfair advantage. It's totally unfair and it shouldn't exist. That's true. But that's the kind of speaking from an affiliation with an industry that hates social media, maybe justifiably, maybe they should be hated. But I am talking about their constitutional rights, and I am talking about the much bigger picture question of what their social function is with respect to free expression. And that's the point that I'm making, and it's independent of whether you hate them, which it's totally reasonable to hate them. But that's not the point that I'm making. What I'm saying is, you know, there's a close association between economic interest and ideals on this.
Yeah, a Marxist might also remind the audience that you advise Facebook. No, but
100%. That's why I started with that.
Right.
That's absolutely why I started. Absolutely why I started.
I'm gonna try to get as many people as we can. I'm gonna go back to DC, to the individual on the other side, and then I'll go to Alex. And then DC after, if you guys could mute, that would be great.
Ask the question and then, yeah.
Okay. Casey Maddox, I'm with the Charles Koch Institute. Last week, I think it was last week, Twitter, at least it was, I can't remember if Twitter actually said this or if it was reported, that Twitter is considering a function that would basically allow anyone to set their account so that no one can reply to your tweets. No one can like or reply to your tweets. So you tweet, you see other people's tweets, other people can see your tweets, but you can set it so that no one can actually reply to your tweets. If Twitter introduces that function, does that moot the case in the Second Circuit? And basically, and that's another way of basically asking the question, this is solely about viewpoint discrimination in that process, right? So basically, if Trump essentially said, this whole swath of people, not based on viewpoint, but because you've replied more than twice, I'm not allowing any of those people to reply to my comments anymore. I'm blocking all of them. That would not be, anyway.
Well, is there a forum anymore is another way of asking it.
yeah, I mean, we had a brief conversation about, the first part of your question at the Knight Institute, and there was some disagreement about what our attitude should be towards this new feature that Twitter is rolling out. But I don't think it would moot the case unless President Trump decided to actually implement this feature. If he decided, I'm not going to let anyone comment on my tweets, then I think there would be an argument for mootness. The mere existence of that feature, I don't think has any effect on the case. One interesting thing about that feature is it might lead a court to think about each tweet as establishing a forum, right? Because a public official could, as I understand it, say, on this tweet I'll enable comments, and on this tweet I won't. And if that's what a public official did, then it might be that the right way to analyze the public forum question is to think about each tweet as potentially establishing a public forum. If it allowed comments, then it could be a public forum, and if it didn't, it wouldn't be.
Can I ask just a quick follow-up? What if they did it so that you have the option, in addition to blocking a follower, you can allow the follower to speak, but down promote the distribution of their comment. It'll still be, they can still speak, and people will still see it, but not as many people will see it. Would that be viewpoint discriminatory? Not because you're not banning them from speaking.
I know my answer to that question, but let me ask you a question first. So let's say we were at a city council meeting, and the city council said anyone who wants to speak can come to the mic, ask a question, we'll answer the question. But people who are critical of our policies, you guys have to line up at the back of the room and use this mic that doesn't actually work. And they're very explicit about this. Is that a First Amendment problem? Because my answer to that question is the same as my answer to the other.
So I don't want to assume that the city council chamber is always a designated public forum. I think there actually is some complicated case law on this. There are some circumstances where it would be, others where it wouldn't. And by the way, that really matters to me, because if even the city council room can employ certain rules that are not, that may actually be content discriminatory, not just content discriminatory, but viewpoint discriminatory. So I just want to note that should significantly undercut our instinct to find limited public fora everywhere. In a limited public forum, would that be viewpoint discriminatory? In a genuine limited public forum? Probably, yeah.
Yeah, that's my answer.
So Alex Abdu, I'm one of Jameel's colleagues. A question for you, Professor Feldman. So I took one of your arguments, which you kind of acknowledged to be a trial balloon here, to be that Twitter has a First Amendment right, maybe associational, maybe expressive, to invite government actors onto the forum and to enable them to engage in viewpoint discrimination. And to the extent that's the argument, I thought that was the argument that the Supreme Court rejected in Southeastern Promotions, because there you had a platform, a privately owned theater that leased out a forum for expression, clearly something about speech. And the Supreme Court disabled that forum from renting it out to a government with what most private lessees would have understood their lease to enable them to do, which is engage in viewpoint discrimination. It is a theater after all. And they said you can't do that. So maybe private entities don't have a First Amendment right to invite government agents to engage in viewpoint discrimination in the use of their property.
So it's a great question, and I actually do have an answer to it. The difference between the theater and Twitter is that Twitter's product, so the theater's product, according to the Supreme Court's analysis there, is a theater, right? And then it had tried to attach conditions, and the court found that those conditions were unconstitutional, effectively, that the government's rental under those conditions would have been unconstitutional. But Twitter's product is, I would argue, the full set of associational interactions. And by the way, I think this is also true as a business matter. The full set of expressive interactions that can take place in its virtual space. And in that sense, its expressive act is to produce this space with these interactions. That is essential to its business model. And so if I were arguing in front of a court and I needed to draw the distinction between those things, I would say that's the distinction. Because
why is the theater owner's interest in deciding who can lease the theater under what conditions not identical to Twitter's decision of who can use the platform under what conditions?
In the same way that when the New York Times invites Donald Trump to write an op-ed, the New York Times can nevertheless choose to control the letters to the editor that are then published. And what I'm saying is, if the New York Times said to Donald Trump, we're going to invite you said to all of its columnists, including Donald Trump, we're going to invite you onto our platform to speak, into our newspaper to speak, and we're going to give you the authority to control the comment thread afterwards. Okay, which is not such a far-fetched thing. Lots of newspapers, they don't want to do that, but some newspapers are doing versions of that now. Then I think the court's holding would not apply in that situation, because the product would still be the newspaper and its set of choices. And in that sense, it would be different from the theater, because I don't think that what the theater was offering was a space with restrictions. They were offering a space, as everyone intuitively understood what theaters do, and then they were adding these contractual restrictions. So that's the distinction that I'm offering. It has to do with what is the essence of the thing they are offering, and that matters if the essence of that thing is itself expressive. So you don't have to buy my view, but it's a conceptual view of what is actually happening on social media. But again, I think it's the reason for the value that exists on social media. The value of these companies depends precisely on the curated forms of social interactions.
But explain that one sentence further, just because lots of products are expressive, and they're still subject to regulation in their creation of expressive products. So why isn't it the same thing? Just because the product you're selling is a mode of expression or a form of expression or just expression itself doesn't mean that your business of putting that out there isn't subject to regulation. Like
well,
the
it does
business
for
doesn't become
it does
expressive.
for newspapers, right? You could say, well, a newspaper just produces a physical piece of paper with little dots on it, and therefore we would be able to regulate. We can't regulate that, but of course we could regulate what the editors say to one another and what their editor. But we don't see it that way. We see the press as an institutional form where the editorial decision process and the writing process is indistinguishable from the physical piece of paper that emerges at the end. And my whole argument, and if this argument is wrong, I think I'm probably wrong about this part of it. My whole argument is that you have to conceptualize, that one ought to correctly conceptualize social media as similarly a product that's born out of expressive interactions. I don't think that's some grand reach. Like, that's what actual people are actually doing all the time on social media. And so the platform, like, you could say, why do we even have these platforms? Why can't I just tomorrow start a website and be like, hey, it's Feldman's Twitter? Like, there's a reason for that. And it's not just first mover advantage that Twitter has. It's that they have invested tremendous resources in curating the precise social forms of interaction that you can titrate and regulate for yourself on the platform. That's what the thing is, in fact.
We have one last question. Floyd, do you mind holding? I'm going to give someone an opportunity who hasn't spoken. Go ahead.
Hi, Marjorie Hines. I'm the advisory board of NCAC. The problem is that social media platforms like Twitter and Facebook are not the New York Times. They are a hybrid. They are service providers, not because 230 says they're service providers, it's because the facts show they're service providers. They assert some control over content, but primarily they are forums for other people's content. In the old days, a Supreme Court might have analyzed these forums as public functions and essentially state actors. We're not going to go there yet, and Jameel is not arguing that either. Both of you are basically arguing that they have First Amendment protection. But I'd like to put out there at least the idea that they are primarily creating forums and therefore subject to regulation. But the issue is complicated by the fact that they are in fact hybrids. They are not exactly shopping centers because they are asserting this editorial control. So that's the dilemma we have, and I'm not proposing any solutions, but I think it is
That's a great,
conceptually very wrong to say they are just like the New York Times.
That's a fantastic point to end on, to invite you guys to respond to that, give any closing remarks you want. But it is true, where we go from here and the dominant role of these platforms in shaping everything that we do, and how does that come into play? So,
Well, I agree with everything that Marjorie just said, but just to go back to a point that I made in passing earlier, I really do think that Noah alluded to the regulatory pressure that the platforms find themselves under right now. That pressure exists only because people have the impression that Congress could regulate. But if you adopt Noah's argument, then that regulatory pressure, to whatever extent it exists right now, is going to disappear, and it'll mean that we will be entirely in the hands of these corporations. These corporations will feel a degree of impunity because they are not subject to regulation that could be imposed on other industries. And these social media companies, this is less true of Twitter, but it's certainly true of Facebook, they really do have the ability to decide elections. If you look at these papers that Jonathan Zittrain at Harvard has written, he goes into the circumstance, these tests that Facebook has run in the past, in which Facebook has made minor tweaks to see whether minor tweaks to people's news feeds could encourage them to vote or discourage them from voting. And even minor tweaks can have a very dramatic effect. And Facebook did this on relatively small, this experiment on a relatively small population. But if tomorrow Facebook decided that, you know what, we want to push people in a particular direction in the presidential election, it could. And if you adopt Noah's argument, it means that Congress can't prevent Facebook from doing it. It can't even require Facebook to say that it is doing it. And I think that that would be, I wish I could remember your phrase, but an epic generational mistake. I don't know what the right form of regulation looks like, for these social media platforms, but ruling out the possibility of regulation right now seems to me exactly the wrong thing to do. But maybe the more important thing I need to say is that all of these questions, whatever you think the answers are to these questions, our case doesn't require you to resolve them. Our case raises a very narrow issue about public officials' social media accounts used as extensions of those officials' offices. It's a very narrow question. Even the social media companies, Noah is more social media company than the social media companies today because the companies didn't take this position in our case. And I think that whatever the answer to these harder questions, our case raises an easy question, and I'm obviously glad that the courts have seen it that way so far.
So just 2 quick points in response to your point. The newspapers were already hybrids. They ran classified sections, which used to be their business model, as you may recall, in the ancient days. And those classified sections were, anyone could post whatever ads they want. Sherlock Holmes is producing of the agony columns. So, that was the space. And under this theory, the agony columns were limited public forums, and the newspaper should not have been able to regulate advertisements that appear there because the default was that anyone could advertise there. Today's newspapers in their online form are just like social media platforms. The New York Times doesn't less rely on letters to the editor. They want engagement. They want to have thousands of people speaking in an engagement conversation in response to every article. That's how they measure the success of their articles. That little thing that's in the shape of a little letter on the top of every New York Times story you read online with a little number in it? That's to tell you how many people have commented on it. And so newspapers are already fully in the business of facilitating public conversations of exactly the kind that the social media do, and the newspapers themselves are in the process of developing the protocols for regulation of that content, including sometimes experimenting with forms of self-regulation, because they're not making it up. That's what the social media platforms are doing. So I strongly disagree with the idea that there's some strict distinction that, in the old days we knew what a newspaper was. And then my last point is, and here I have to say I'm trembling a little bit. So, it's one thing to hear, Josh Hawley talking about the great goal and value of regulating social media. It's another thing to hear Elizabeth Warren talking about modes of regulating social media. That's all fair and good. But I'm sitting here with the person in my generation who I think has, I've been more allied with and who's done more to make something close, not a pure absolutist, but a very, very strong set of free expression arguments in a wide range of contexts. And I'm always like, go Jameel, yes, like someone is standing up for the freedom of expression in a period where, I will tell you, I teach First Amendment at Harvard Law School. I've been doing it now for about a decade, and my students are far less speech protective today than they were a decade ago. Among the center-left, speech protection is undergoing one of its worst periods certainly in my lifetime, and I think arguably in a long time. And in that environment, the argument that the social media platforms are very powerful and therefore we should regulate them, which is, I think, the essence of the argument. They're very powerful. They can affect the outcome of elections, these people who handle expression. I mean, that's exactly the argument that for 400 years censors made about newspapers. Public opinion didn't exist. Read any history of modernity. There was no such thing as public opinion before there were newspapers. Public opinion was produced. Modern democracy was produced. The nation state was produced out of newspapers. And the argument for regulating them was always grounded in their tremendous power. Their power to control the direction of discourse. Their power to shape the outcomes of elections. Their power to bring governments to rise and to fall. Their power to produce genocides. And you know what? In the last couple of hundred years, newspapers did every single one of those things. They led religious reformations. They drove violent revolution. They drove some of the most progressive transformations that the human soul has ever seen, and some of the most horrifying actions that humans are capable of. And social media platforms, for all that one wants to claim that there's something new and different, they're exercising comparable power today. And it's just a subtle shift. It's not even that big a shift. It's just a subtle shift in how the expression works. They still curate and gather content, and they simply have introduced this extra feature of enabling individuals to participate in the self-curation process and in producing of interactive networks. So to me, it's a real test of how deep one's commitment to free expression really is. And I want free expression to come out ahead. And by the way, I don't think what I'm saying would be broadly accepted within Facebook at all. I don't think Facebook would agree with 90% of what I've said, okay? I don't think the industry itself, and I've worked closely with them, I think the industry itself also doesn't get at a fundamental level that they are the frontier of free expression. They are welcoming Mark Zuckerberg, whom I've worked with closely on this. He's welcomed all kinds of governmental regulation of content. That's a business decision that he's making. And he's a person who believes in free expression, in fact. But I don't think even he invented the darn thing. I mean, not social media, but he invented this company. I don't think he even sees this in the terms that I'm describing it as being. So I'm arguing that at the deepest level, free expression now has shifted in terms of the space in which it occurs, and that therefore we ought to think of those institutional actors in just the same way we think of the legacy institutional actors. So thank you for letting me try out the ideas, and I don't expect anyone to believe them, but maybe in 25 years things will look different.
No, this is great. Apologies to anyone we didn't get to. I am very heartened that we were all here in person, not virtually, engaged in this very spirited debate. You guys both were a great testament to freedom of expression tonight.
For those of us who believe in the Enlightenment function of the First Amendment, today was a glorious evening. And what you heard this evening should be heard in every First Amendment classroom in the country. And I'm certainly going to go to great effort to make sure that happens with the video we have. But will you all join with me in thanking Jameel, Noah, and Francesca?